Ms. Hageman made a series of what are essentially appellate arguments.
A couple of things. To conflate the outcome of the two cases between Hunter Biden and President Trump is an absolute absurdity. It's also an absurdity to claim that the outcome in one case with Hunter Biden being convicted today is reflective of the viability or legality of what happened in New York is also absolutely absurd.
Maybe she'd enlighten us as to the difference?
I'd be happy to, but I do not understand why that would be at all relevant to the discussion that we're having today. But I'm happy to have that debate with you any day of the week. It's in the fact that the expert witness, who is the former head of the Federal Election Commission, was excluded from testifying as an expert witness in the case in New York, despite the fact that he has been qualified as an expert witness to testify on these matters throughout the entire United States. It is the fact that there were other witnesses that were excluded. There was substantial evidence, prejudicial evidence, that was admitted during the course of the trial.
She says that this or that witness should have been allowed to testify beyond the domain that the judge allowed him to testify. For example, Brad Smith was allowed to testify within a certain range, but not on irrelevant things. Now, she says, it should have been the full 100 yards of the football field and not the 20 yards that he was allowed to testify on. Great, that's an appellate argument. Ms. Hageman sounds like an excellent criminal defense appeals lawyer, but is it grounds for attacking the rule of law in America and the system of justice in New York, much less the federal system of justice, which had nothing to do with it? And they're deliberately confusing people about that. Hunter Biden was prosecuted by federal prosecutors in federal court. Donald Trump was prosecuted in that particular case in state court by state prosecutors. I thought state law and the federalist system was something they supported, but apparently not. Not if it goes against Donald Trump. They're willing to just throw the whole thing out the window. I'm struck by Ms. Hageman's remarks because I'm actually amazed at the similarities between these two cases. Both Joe Biden, both Hunter Biden and Donald Trump were given the presumption of innocence. Both were given a jury trial. Both had a right to counsel, which they exercised by paying for exceptional private counsel. Both of them had a right to testify. Neither of them chose to testify, including Donald Trump, who now wants to testify to the world about how the fix was in and it was rigged and all that stuff, but he wasn't willing to get up on the stand and testify about why he didn't do it. No, he didn't want to do that. Fair enough, he exercised his constitutional right. Both of them had a right to a jury trial, and both of them had a right to a unanimous verdict. And in both cases, the jury unanimously found, in Trump's case, that he was guilty on 34 different counts, and in Hunter Biden's case, that he was guilty on 3 different counts. Donald Trump, as far as I know, is going to exercise his right to appeal. So I'm happy, to go outside with you, Ms. Hageman, and you can give me 3 hours of description of what the appellate arguments are going to be, but ultimately an appellate court is going to sort it out. I'm a little bit more interested in just the rule of law and in justice. I'll quote a former colleague of ours, Liz Cheney, who was the head of the Republican conference, and she said, "At this moment, we're confronting a domestic threat that we've never faced before. That is a former president who's attempting to unravel the very foundations of our constitutional republic." I don't know if you guys remember Liz Cheney, but she said, "Republicans cannot both be loyal to Donald Trump and loyal to the Constitution at the same time," she said. So that's in honor of a very distinguished Republican colleague, former colleague of ours.
Thank you, Mr. Raskin. You raised some interesting points. I mean, this whole process here, the 3 committees, the relentless search for nothing, apparently, really has smacked of political theater. And you raised the point that, if this is about oversight and enforcing congressional subpoenas, how can it not be a partisan effort when they dropped enforcement of the subpoenas for Jim Jordan, for a host of people who allegedly conspired with the president to try to subvert the election results on January 6th. Yeah. I mean, they've dropped all of that enforcement.
We don't have to be naive about partisanship. Partisanship is built into our constitutional system. It's an expression of constitutional health, that people have a right to participate, to form political parties, to, express themselves in that way. On behalf of our colleagues, they would probably say that Jim Jordan and Scott Perry and Andy Biggs and so on, that they had whatever legal arguments they wanted to raise against being subpoenaed there, okay? But so does the Attorney General of the United States. So they would have opposed a contempt motion against Jim Jordan or Andy Biggs or Mo Brooks or Kevin McCarthy. But why would they support a contempt motion when there's a reasonable difference of view about whether an audio tape and a transcript serve the same function, especially when this Attorney General and his administration have gone way beyond whatever any of our GOP colleagues did in terms of complying with a subpoena, and way beyond whatever Donald Trump ever did in terms of complying with the subpoena. So we all are partisans here. We don't have to play make-believe about that, but we at least should try to adhere to some basic principles as opposed to just turn on and turn off our principles according to whether it's going to affect the Democrats or the Republicans.
Thank you. I think at this point, I'd yield back. Thank you.